Ladies and gentlemen, welcome to the National Constitution Center. I am Jeffrey Rosen, the president of this wonderful institution, which, as a few of you may know, is the only institution in America chartered by Congress to disseminate information about the U.S. Constitution on a nonpartisan basis. Bravo. You see, Senators Coons and Lee, how very well trained our superb audience is. They are able to recite our congressional mandate like a catechism, and we remind ourselves of it at all times, even during this exciting political week ahead of us. This is a great conversation with these two incredibly distinguished senators about the Senate and the Constitution. It is part of a series of constitutional conversations we're having with our new honorary congressional visiting scholars. And we're so thrilled that Senator Coons, along with Senator Mike Lee from Utah, have agreed to be our first visiting scholars from the Senate. Representative Amash and Zoe Lofgren are our first scholars from the House. We'll hope to con Senator Durbin into doing this as well, if he likes our conversation too. But the basic idea is that it's important that there should be one place in America that brings together R&D Congresspeople and senators for constitutional discussions about the central constitutional issues facing our country. And it's a thrill to convene them, and we're so glad that you're here. So we're going to jump right in. There are a whole series of discussions that both of these senators have been leaders about. And I want to begin with Senator Coons, our visiting scholar, and begin with the question of voting rights. There is an important bill that's pending called the Voting Rights Advancement Act of 2015. Both of you have been involved with it. I want you to tell us about that act. What would it do, and why do you support it?
Well, Jeff, first, thanks to you and to everybody here at the National Constitution Center, and thanks to my good friend, Senator Dick Durbin, for joining us here today in the Delaware suburbs in Philadelphia. It is exciting to have a chance to once again be at the Constitution Center. Voting is one of the most foundational rights in our democracy. The access to the ballot box is something that America worked hard to improve over the centuries, the 230 years since a constitutional convention gathered just down the way here. And we are about to celebrate in 2020 the centennial of the 19th Amendment that gave women the right to vote. And dare I say, on a partisan basis, with or without any agreement from Jeff, it would be fantastic to celebrate the centennial of expanding the franchise to the majority of the American population by having our first female president marking that centennial. Voting rights is something that has sadly been significantly under attack in recent years. As you well know, in, I believe, an ill-advised decision by the Supreme Court, Shelby County, they struck down a section of the Voting Rights Act of 1965. And the fact that this will be the first presidential election without the protections of preclearance, without the protections of Section 4, is something that I think is a grave challenge to our democracy. Senator Durbin, when he chaired the Constitution Subcommittee of the Judiciary Committee on which we both serve, conducted a whole series of field hearings and conducted what for me was a very memorable hearing in the Senate about this fallacy that there is widespread voting fraud that justifies the literally hundreds of new laws at the city and county and state level that are significantly restricting access to the right to vote. And so I'd like to turn it over to Senator Durbin, ask him to talk about a bill of which I'm proud to be a co-sponsor, but where he has really led the fight to make sure that we are restoring access to the ballot box and that we are restoring the full vitality and strength of the Voting Rights Act. Senator Durbin?
Thanks, Chris, and thanks, Jeff. Thank you for inviting me here today. It was a dream come true to be the chair of the Senate Judiciary Subcommittee on Constitution, Civil Rights, and Human Rights. What a day at the beach. And I was able to really propose an agenda for this subcommittee. And Chris is correct, we took our show on the road. So I took it to Cleveland, Ohio, and we had a meeting there because the state of Ohio had just come up with ID cards and reduced opportunities to vote early and such. And I brought in elected and sworn election officers of both political parties for my first panel, put them under oath and asked them, first question, what was the incidence of voter fraud in Ohio that led the General Assembly legislature in your state to restrict opportunities to vote by requiring IDs and such? None. Okay, then let's be more specific. How many cases of voter fraud have been prosecuted in the last 10 years in the state of Ohio? And the one Republican witness said, well, that's an unfair question. I said, why is it an unfair question? He said, well, it could be voter fraud that doesn't rise to the level of prosecution. But it rises to the level of prompting you to change the law for every voter in the state of Ohio? I did exactly the same thing in Florida. Same panel, same result. Let's be honest what this is about. This is about suppressing votes. This is not a question of making sure that there's authenticity in voting. It's about suppressing votes. I rarely recommend a book that I haven't finished, but I'm so excited about a book I just started that I recommend it to you, called White Rage. And it's by a professor from Emory University named Anderson. And what she has done is to tell the history of Reconstruction and the Black Codes and what we have gone through as a nation since we decided to abolish slavery with the 13th Amendment. And what they did in voting, you kind of know intuitively, but when they get into specific, it's an outrage, where you would have 4% of the electorate showing up in a southern state for an election. The rest, not interested or disqualified. The outrages that occurred when it came to the basic right to vote in this country led us to the Voting Rights Act in the 1960s. And of course, Lyndon Baines Johnson's comment, we're going to lose the South for a generation or more. Well, there's some truth to what he said, unfortunately. And it really reflects the fact, not that the North is without fault in this, but it reflects the fact that what went on in the Reconstruction era is an outrageous pattern of conduct which we cannot allow to continue or return. In this case, with the Voting Rights Act, I think the Supreme Court just missed it. You know, they want to say, well, we've turned that page on racism. Come on, we know we haven't. We know that this is the original sin, and we will continue generation after generation coping and dealing with it and trying to make this a fair country when it comes to voting.
So the original amendments to the Voting Rights Act of 2006 passed by overwhelming bipartisan majorities and were signed by President George W. Bush. Does this Voting Rights Advancement Act have a chance of passing? And maybe a few more details about what it would do.
Well, it would restore pre-clearance, but not based on the formula that was used in the original Voting Rights Act of 1965. Shelby County, the decision by the Supreme Court, criticizes in some detail the sort of fact-finding, the factual basis of the congressional reenactment. Some would argue that this was a significant overreach by the conservative majority in the court that removed that section from the Voting Rights Act. I'll express frustration with Congress that we haven't stepped up to the challenge on a bipartisan basis and renewed, reinvigorated, reauthorized, and expanded Voting Rights Act that deals with the challenges we face today. I believe, and the Senator will correct me if I'm wrong, that there is one Republican senator, Senator Murkowski of Alaska, who has joined us as a co-sponsor. I'll tell you that I went to Selma with Congressman Lewis at the 50th anniversary of the march, and carrying a copy of a bill that is very similar to the Voting Rights Advancement Act, went to a number of Republican colleagues who were there to celebrate the 50th anniversary of the march and asked them if they would join as co-sponsors, and was unanimously rebuffed. So I struggle to know what it is that is so unsettling or scary to my Republican colleagues about an updated, current, relevant pre-clearance formula. This would put in place that, and it would require pre-clearance for a whole series of what are called known practices, changes in access to the ballot box, changes in the structure of elections that have been demonstrated over decades to have a disparate impact on racial groups. Part of what motivated Senator Murkowski, if I remember correctly, to join us as a co-sponsor was the native rights implications, the implications for Native Alaskans of some of the voting practices that we now see emerging around the country. I'm very concerned about this election. This will be the first presidential election without the full protections of the Voting Rights Act. I'm deeply frustrated that Congress hasn't been able to come together in a bipartisan way. Fighting for the abolition of slavery and fighting for access to the right to vote was historically something the Republican Party was very proud of. And it is my hope that at some point the Republican Party returns to its historic roots of seeing the right to vote as one of the most foundational of the constitutional rights guaranteed to our citizens.
Fascinating about your trip with Congressman Lewis. Ladies and gentlemen, you know that we are giving Congressman Lewis the Liberty Medal on September 19th, and hope you will join. Senator, and just to recall the details of this thing, pre-clearance means that a state that's discriminated in the past on the basis of voting has to get approval with the federal government before it can change its voting practices in a way that might harm minority voting rights. And it was the formula for determining which states were covered that the Supreme Court struck down in the Shelby County decision. Senator Durbin, just descriptively, because the politics are relevant to the constitutional question, why did the voting rights extension pass unanimously in 2006 or nearly so, and why has it become such a partisan issue now?
There are changes that have taken place on the political scene, and Citizens United is behind every door. But the changes that have taken place, I think there's been a conscious decision by the Republican Party that they have to suppress certain votes because they're losing in the demographic analysis. They're pushing away from the largest growing minorities in America, Hispanic Americans. They are not moving in any way toward the African Americans in terms of their agenda in any significant fashion. And so what they've done is decide there's going to be a different strategy here. And that strategy will be several elements in it. Change the Voting Rights Act and not join in the bipartisan effort to extend it that we saw, as you mentioned, just a few years ago. But it also comes back to the appointment of judges. We have 90 vacancies now in the federal judiciary. This year, I think my numbers are right, 20 or 22 federal judges have been approved. We have 27 sitting on the calendar of the Senate, 26 of which unanimously went through the Senate Judiciary Committee. So here we have 22 approved in the last year of the Obama presidency. What did we do in the last year of the George W. Bush presidency? 68. Why are we holding back, at least with the 27, of no controversy? And we still report them out of committee with regularity, send them to the calendar to languish. The hopes that Donald Trump will fill the vacancies. They're being held on the calendar. So when it comes to the appointments to the judiciary, starting with the Supreme Court, which we'll probably discuss later, there is also this strategy underway. All of these strategies are designed to overcome what would happen if 100% of Americans voted. Which would be a dream come true for some. But that, to me, is part of this strategy. That is what's changed it. It's a notion that we are going to suppress votes. We are going to invite what I consider to be historic mischief in interfering with people's basic rights.
We will talk about judges a bit later, but I want to stay on the voting rights question and ask about felon disenfranchisement. So we just had a phenomenal panel over in Congress Hall, which was the original meeting place of the House of Representatives in Independence Hall, with presidential historians, and we talked about the Reconstruction Amendments, the 13th, 14th, and 15th Amendments. The 14th Amendment turns 150 this year. We are celebrating its 150th anniversary all year. It's the central guarantee of equality in American history. And Section 2 of the 14th Amendment says that states may abridge the right to vote of citizens for participation in rebellion or other crimes. So as some have interpreted it, this gives states the authority to deny voting rights to people with criminal convictions. A bunch of states have done that, but there's an effort to overturn that. Senator Reid has introduced a bill called the Democracy Restoration Act. Senator Durbin, you've supported that, which would restore voting rights in federal election to millions of Americans who are out of prison. And Governor McAuliffe in Virginia, among other governors, has tried to restore felon voting rights. Senator Coons, tell us about why you think that this restoration is important.
I'm also a co-sponsor of the Democracy Restoration Act, which would immediately restore voting rights to 1 million convicted felons who are out of prison, who are not incarcerated, and would accelerate their full rehabilitation, their full re-engagement with civil society. My home state of Delaware is one of many that has undergone a journey from a place where there were disenfranchisement statutes on the books that made sure that felons would virtually never return to the voting populace. And in a series of enactments by our General Assembly, signed into law by our Governor, Jack Markell, over recent years, we've moved from being one of, sadly, many states where certain felony convictions meant you were unable to vote for life, to 5 years after your incarceration ended, to promptly upon incarceration, but only after you fully paid fines, to most recently, a bill was just signed by our governor saying that when you have finished serving your debt to society as a felon, when you're no longer in prison, your voting rights are restored. There are roughly 6 million Americans who cannot vote because they are convicted felons. And there's a number of landmark cases at the federal level and the state level that determined that which felonies were a basis for disenfranchisement in certain states were designed to disenfranchise the maximum number of African Americans. That some felonies were not the basis for disenfranchisement and others were. And in a particularly galling series of cases and opinions, it was made clear that there was a voter suppression instinct at the base of some of these state statutes. There are 2 American states that allow felons to vote from jail. The other 48 still don't.
What are the 2?
I forget, they're in New England, Senator Durbin.
Maine and Vermont.
Maine and Vermont.
Nice.
So, there is sort of a wide range of views from, lifetime disenfranchisement to you can vote from jail. I do think we have to be conscious of the significant racial disparity and impact of incarceration. In the last 16 years, incarceration has grown 500%. We have the largest prison population on earth, and it has had a significant disparate impact on the access to the ballot box of African Americans. So to look at the disenfranchisement of felons without looking at its racial impact, without looking at its electoral impact, I think is to miss some of the real intent of the disenfranchisement statutes adopted after the Civil War or adopted in the early parts of the last century, and to miss the impact on the full re-engagement of felons in civil society once they finish serving their terms in prison, that I think is also a positive outcome. So this particular statute would affect federal voting rights for all felons who've completed their terms of service. And I think it's just one of a number of important criminal justice reform efforts that Senator Durbin has led. He's also been a real leader on criminal justice reform with regards to sentencing, both at the front end and at the back end.
I want to ask you about sentencing in a moment, but on felon voting rights, why did you become engaged in this question? Tell us about what's happened in Virginia, where Governor McAuliffe's effort to give clemency to 200,000 former felons was recently overturned by the Virginia courts, who said he had to do it on an individual basis. And do you believe that all felons should be able to vote, or are there certain crimes that should be disqualifying?
Well, let me preface it by saying in Florida and Kentucky, more than 1 in 5 black adults is disenfranchised. Nationwide, 1 of every 13 black adults is disenfranchised. Terry McAuliffe made headlines when he published an executive order restoring voting rights to 206,000 Virginians who had completed incarceration and supervised release. He also established a monthly process to restore voting rights for individuals who complete their sentences. Lawsuits filed, and last Friday, 4-3, Virginia Supreme Court overturned his order. He says in response he's going to begin issuing pardons on a case-by-case basis. 206,000. So it remains to be seen exactly how that will play out. I believe we'll be talking about sentencing, I think perhaps in another part of this, so I'll save some of these comments. But I believe that, as Chris has said, the disparate impact of sentencing, criminal sentencing, on minority populations, especially African American, is something that we can no longer just look away from. We have to look and focus on it. And we know that we are over-incarcerating and over-sentencing, and it hits the black population the hardest. And if that is the case, to think that we are denying a fundamental right to people who have served their sentence, paid their fines, and now simply want to return and be part of the mainstream of society, to me, is just unconscionable. That isn't what we're all about as a nation. If we establish a sentence for a crime that's imposed and served, at that point, for goodness sakes, you ought to be able to turn the page and start a life. And I think voting as a part of the civic adventure is the starting point.
Great. Well, you mentioned sentencing reform, and let's talk about it. Both of you have supported an extremely important and strikingly bipartisan effort at sentencing reform. Senator Coons, tell us about the sentencing reform bill, what it would do, and why you support it.
My recollection is that the bill that both of us have co-sponsored affects 3 different pieces. And remember, this affects federal sentencing. The vast majority of those who are incarcerated under state law and state prisons. So it is our hope that progress on a bipartisan basis on sentencing will then have some impact at the state level. First, it's in reducing mandatory minimums. Mandatory minimums that have been shown to be disparate in their impact and where they are unduly long and restrict the ability of judges to make individualized sentencing determinations, particularly for nonviolent drug-related offenses. The other is in the back end, allowing judges some ability to offer early release to those who've been model prisoners and who've gone through certain recidivism reducing programming. And then third, lightening some of the impact of a 3 strikes and you're out federal statute, which leads to a life sentence for a third conviction. It's got a series of different factors. It's a fairly complex bill, and Senator Durbin has been more actively involved in crafting the compromise than I should take any credit for. But it can have a big and a significant impact on criminal justice. One other thing that I was pleased to see President Obama take up, but I'm hoping we can do legislatively, is to reduce the use of solitary confinement, particularly with juveniles. Solitary confinement has a dramatically negative mental health impact on prisoners, and the use of shackles and solitary confinement for juveniles is something that I think we need to really re-examine, because its impact on juveniles and its impact on those who are long time incarcerated in the federal system has been demonstrated to be very negative. Obviously, we have to keep in mind safety in courtrooms and safety of corrections officers, but I think we can and should strike a better balance.
Fascinating. Senator, you have been such a leader on this question. It's really striking how bipartisan the support is. Senator Coons' fellow Constitution Center scholar Mike Lee has been very enthusiastic in his support of your bill. Tell us why Senator Lee and other Republicans have joined you in this effort. Why are you pushing it forward, and might it actually pass?
Well, I'm going to say something you won't hear very often from a member of Congress. Let me tell you about the worst vote I ever cast in Congress. It goes back over 20 years ago. I was a member of the House of Representatives. A basketball player in Maryland named Len Bias was destined for the NBA, overdosed on drugs, and died. The reaction across the Washington, D.C. area was huge, because everybody knew this man and how good he was. And then came the response in Congress. Correctly or incorrectly, crack cocaine was blamed for his death. And we were told, as members of the House of Representatives, that we had to take decisive action on this new narcotic, which was dirt cheap, $5, terribly addictive, much more so than any other narcotics that we knew at the moment, and was devastating to pregnant women in terms of the baby that they would ultimately deliver. And we certainly did react. We overreacted, and I voted for it. Members of the Black Caucus voted for it, thinking we've got to take a stand on crack cocaine. What we did was to change the sentencing guideline for crack cocaine and made it 100 times the sentencing for powder cocaine. 100 times. We were going to get the message across. Well, what happened in the next 20 years was devastating. It was primarily a crime charged against African Americans, and the sentences just went on and on and on for minute amounts of crack cocaine. And then we reached that point where there was reaction in the jury box, where African Americans sat on juries and said, not guilty. We know what's going on out there, and we know who's being convicted for it. And then we got into a conversation about changing it. So I introduced a bill which said this should be 1-to-1. There is no proven difference in the efficacy or damage between powder cocaine and crack cocaine. So I put the 1-to-1 bill in, and so I'll tell you how laws are made. Maybe this is a place to bring it up. How laws are made. I put in 1-to-1, and I start the negotiation, and it turns out that my adversary on this is Jeff Sessions of Alabama. Thank you, God. And so we started talking, and luckily for me, and I want to say to his credit, civil rights leaders in Alabama started meeting with him. Church leaders started meeting with him, telling him stories. Now, I won't go into the long story on Jeff's background with the United States Senate. Some of you already know it. But he was a former prosecutor, so he's a pretty tough character when it comes to this. So we started the negotiation, and it wasn't going anywhere. And finally, and this is true, the day of the markup in the committee, when the bill is about to lose, I'm in the Senate gym. I go to the Senate gym every morning for no apparent reason. But I run into Jeff, and he comes in the Senate gym, and I say, Jeff, come on, buddy, we've got to come up with a number. I've got 1-to-1, what will you take? Back and forth and back and forth. And so I said, okay, it's 100-to-1, let's go, can we get to 10-to-1? No. What will you take? 25. 25-to-1, he said. And I said, how about splitting the difference? Let's make it 13 or 14. He said, I'll take 18. I said, I'll take it. How laws are made. We went into the committee and took 18-1. It passed out of the committee by a voice vote. It passed the Senate by a voice vote. House Judiciary, voice vote. House Representatives, voice vote. Went to the president's desk. It was the most sparsely attended signing ceremony in the history of the White House, as Barack Obama signed it in front of Jeff and me. The net result of it was to eliminate 30,000 years of federal incarceration, because the Sentencing Commission decided to apply it retroactively to allow people to petition. And it meant it cut off that additional sentencing which they would have faced. So having done that, as Chris described to you, I decided to start working on a larger scale on this mandatory minimum, which, coupled with this earlier decision on crack cocaine, led to just incredibly unfair results. Alton Mills, Chicago, Illinois, 22 years old, runner for the drug gangs, no guns, no gangs, no violence in his life. 2 arrests and convictions for the sale of crack cocaine, no time in jail. 3rd strike, life in prison. Life in prison. The president commuted his sentence after 22 years. 22 years for a handful of crack cocaine. So we wanted to get beyond the 3 strikes and the mandatory minimum. So who did I draw in as my allies? Mike Lee. Now Mike is a proud Tea Party Republican, but as a prosecutor in Utah, he had a case just like this and couldn't believe how outrageously unjust it was, and the judge's hands were tied by the laws that we'd written. So Mike joins me in a good bill, easily described, which got a good start. When we had the press conference and I was standing there with Pat Leahy on one side, and then I turned around and I saw Ted Cruz on the other side. I said, Ted, one of us has not read this bill. That was the early version of it. But we couldn't get Chuck Grassley. He was against it, and he spoke against it. He was vehement. I thought, we'll get nowhere. He's the chairman of the Senate Judiciary Committee. We won't even get a hearing on this bill. So we sat down, literally worked for a year to get a different version of the bill. And good, not as good as the original, trust me, but good. And Grassley, it was a co-sponsor. John Cornyn, because of the back end on sentencing, was a co-sponsor. Passed it out of the committee 15-5. Sitting on the calendar since last October. Why? Mitch McConnell's scared. Mitch McConnell is looking at this and saying, I don't want this vote for my Republican caucus. You know, shades of Willie Horton. He's afraid of what will happen in the election. I think he's wrong. I really believe public sentiment has moved forward on this. And we have the support of prosecutors. We have the support of police organizations. We should move forward. I don't think there's a chance we'll do it this year, but I wish we would.
Chris, you've worked with your fellow NCC scholar, Mike Lee, and there's a great convergence of people from the Koch Foundation to the ACLU about the dangers of overcriminalization. Tell us more about that bipartisan alliance, and might it pass after the election?
Well, it's my hope that we might be able to take it up this Congress in the lame duck, because so much hard work has been done, as Senator Durbin described, and so much progress has been made. But we're going to have a very tight calendar, relatively little time and a lot of potential issues. It is my hope we will finally give a hearing to Judge Merrick Garland of the D.C. Circuit Court, who, Article 2, Section 2, our constitutional responsibility, the president nominates and we provide advice and consent. Advice and consent surely cannot consist of refusing to have a hearing and refusing to take a vote. So in the short period in what I think will be a very busy lame duck session later this year, it is my hope that Judge Garland will get a fair hearing and a vote. It is also my hope that the Sentencing Reform Act would get some consideration on the floor. I'll agree with Senator Durbin that Senator McConnell's been pretty blunt about being concerned about the electoral consequences. I'm going to loop back and give credit to one senator he referenced and a conversation we had in the gym that actually also produced a positive result. Because of sequestration, the across-the-board funding caps, and because of the way the federal judicial budget works, the public defender service, the federal public defender service, was savaged. The cuts were unbelievable and led to significant reductions in staffing. And to make a long story short, Senator Sessions, who was a former federal prosecutor, to my surprise and delight ultimately, worked with me to restore full funding to the Federal Public Defender Service. Because although he had been a prosecutor, he recognized that having someone on the other side of the table representing the defense side who wasn't experienced, who wasn't competent, who wasn't well-trained, led to improper, incorrect, and unjust convictions. So we had a similar conversation early one morning. I didn't get everything I wanted, but it is possible for us to work across the aisle on issues that relate to fundamental justice, and in particular where the Constitution is implicated. Sadly rare, but it is possible.
Judge Garland has come up a bunch of times. Senator Durbin, I asked Senator Klobuchar in a recent interview whether Judge Garland would be confirmed if Senator Clinton wins in a lame duck session. She said she thought he might get a hearing. What do you think?
It's possible. Chuck Grassley has been the focal point of this. I don't think he devised this strategy, but he's executing it, which means, as Chris mentioned, no hearing, no vote. And this is the first time ever, underline, ever, in the history of the United States that a presidential Supreme Court nominee has been denied a hearing and a vote. First time. Chuck Grassley paid for it dearly back in Iowa, continues to pay the price. His approval rating has gone down 20 points since this was announced. And ironically, he has an opponent whose name is Pat Judge. So I think there's going to be a feeling in the Republican caucus that they want to square this up. And Merrick Garland, when he was nominated for the D.C. Circuit Court, had a lot of praise from Republicans. He was a good choice by the president because he'd gone through so easily with a bipartisan vote. So I think it's possible that they'll do it in the lame duck. The problem with the lame duck is it's not that long a period of time. And we've saved up so darn many things for it, you know, and it get a break to at least eat a Thanksgiving turkey and Hanukkah, Christmas. So there's a limited amount of time in those 2 months to do a lot of work. And if this takes a week for a hearing and then a week for it to hit the floor, it may not be possible physically.
What do you think, Senator Coons? And, you know, if Secretary Clinton wins, she may face some pressure from progressives to appoint a more liberal justice. Will she stand by Garland, and might he be confirmed in the lame duck?
Well, I can't speak to Secretary Clinton's view about who she would or wouldn't nominate, but I'll point out, I think you just wrote about this in the New York Times, that it's been a century since Justice Brandeis had as long a wait, the previously longest wait from nomination to hearing to confirmation of any nomination to be a justice. And now Judge Garland has waited longer than anyone for a hearing and a confirmation. I understand there will be some pressure to not act and to instead, in the next administration, should it be Secretary Clinton, who's elected in November, to renominate someone 15, 20 years younger, or someone who has a more demonstrably progressive record. But I'll say this about Judge Garland. He is one of the most decent, capable, thoughtful judges I've ever met. His 19 years on the D.C. Circuit make him the most experienced and, I would argue, qualified circuit court judge ever nominated to the Supreme Court. And so I understand there are many who are sort of agitating for a new nomination, but if anyone deserves consideration, just based on his judicial record and his personal traits and his dedication to public service, Judge Garland is a truly outstanding circuit judge.
We're talking about the Supreme Court. Let's talk about immigration. Senator, you've been a leader on immigration reform. In a 4-4 split decision, the Supreme Court divided about the legality of President Obama's deferred deportation plan, leaving in place the lower court order halting it. What do you think of that decision, and what is the prospect for immigration reform?
It worries me. 15 years ago, I got a call in my office in Chicago. 18-year-old girl from Korea had been offered a music scholarship at Manhattan Conservatory of Music in Juilliard. When she filled out the application form, she reached the point where it said nationality, citizenship. She said to her mom, "What am I?" Her mom said, "You came in on a visitor's visa. I never filed any more papers. I don't know." Girl says, "What are you going to do?" Mom says, "We'll call Durbin." So they called our office, and it turns out her prospects under the law were pretty grim. Leave the United States for 10 years and petition to return. thought to myself, that ain't right. She came in at age 2. She had nothing to do with this decision to come to the United States or the failure to file any papers. So I wrote the DREAM Act. When I filed the DREAM Act, I got a call from Orrin Hatch. Madder than hell. What's the matter, Orrin? You stole my idea. Really? I just was working on the same bill. And I said, well, since the Republicans are in the majority, Orrin, why don't you be the lead sponsor and I'll be the co-sponsor? That's the way it'll be. So the first 2 years it was Hatch Durbin, and then he kind of fell out of love with the concept and opposed the concept and voted against the concept. But that was a negative evolution. Put the bill in 15 years ago, never enacted it into law, that we've tried, passed it in the Senate various times, House various times, never the same year. And so a fellow from Illinois named Barack Obama as senator was a co-sponsor, and after we failed on the floor, I called him and said, I wrote him actually, with Dick Lugar, bless him, the only Republican gutsy enough to co-sign the letter, Mr. President, use your executive authority. Spare these kids from deportation. And I got no response. I waited and about another 10 months, did the same letter with 23 senators signing it this time. And then came DACA. DACA basically said if you'll pay about $460 in fees, submit to a criminal background check, register with the government, we will give you 2 years, spare you from deportation. And the president signed the order, and DACA has now protected 760,000 young people in the same predicament as the girl from Korea. He expanded that definition in his second round on DACA, and then created DAPA if you have an American citizen child. As parents, you can get this, what is temporary relief from deportation, temporary right to work and such. So at this point, the court, it was challenged. The challenge was very bizarre. I listened to the hearings in the court. 23 governors from all Republicans, with Texas as the lead, came in and argued that expanding DACA so that these young people would not be deported would be an unconscionable financial burden on the states. We have all these analyses to say that when they start paying taxes, they're a plus to the treasuries of states and to the federal treasury. But they argued they would have to issue more driver's licenses, and they lost money each time they issued a driver's license. Well, who determines how much the fee is on a driver's license? It's the state, obviously. Nevertheless, it prevailed, or at least in the lower courts, and came up for a 4-4 tie with this Supreme Court missing a justice. And now it goes back to Judge Hannon of Texas, carefully chosen originally to oppose this law. What troubles me the most about this is that he has requested the names and identities of all those who've applied for DACA. Talk about a scary prospect for these kids. This was the one thing they feared the most, that they were turning themselves in for deportation if this didn't work. So I worry about that an awful lot. Footnote on the story. Whatever happened to Teresa Lee, the Korean girl? She went to the Manhattan Conservatory of Music. She got a master's degree and a PhD in music. She played in Carnegie Hall, and she's since married an American, has a baby, and she has her citizenship. So it worked out fine for her.
Beautiful story. Just for the acronyms, because I always get them confused as well, DACA is Deferred Action for Childhood Arrivals, and DAPA is Deferred Action for Parents of Americans, and that's this fascinating story about Senator Hatch as well. Senator Coons, thoughts on the future of immigration reform, or do you want to talk about campaign finance?
Well, I think one of the most important bills that we worked on together led to one of the longest Judiciary Committee hearings I've had the chance to participate in, was comprehensive immigration reform. It ultimately passed the Senate by, I think, 67?
67, 68.
60 votes, and reflected, I think, the best of bipartisanship. It was hammered out by a group of senators. Senator Durbin contributed significantly to it, not just the DREAM Act, but across a whole range of issues. And it really would have made a significant step forward. It was literally never taken up in the House. So it is my hope that in this election, where sadly we see one presidential candidate using divisive language, using nativist and xenophobic language, it is my hope that the outcome will then lead to the other party recognizing that making real progress in immigration reform, recognizing that there's 12 million people here in this country who we cannot possibly consider rounding up and deporting while still respecting civil liberties and retaining the balance of federal and local power, that they'll join us in moving forward with a responsible and balanced comprehensive immigration reform bill in the next Congress. But it's a huge amount of work to reassemble a lot of the same coalition. There is very broad support across a remarkable array of faith and corporate and civil liberties and human rights organizations all over the country. And there's a lot of reasons why adopting comprehensive immigration reform would have a positive impact on the United States, economically, in terms of civil liberties, in terms of social integration. I think there's going to be a real argument to be made for it following this election. That's my hope. It's going to be one of the central and defining issues in the campaign. Certainly, if you watched any of the Republican convention in Cleveland, they dedicated a whole evening to their dark and fairly negative view of immigration and of the contributions of immigrants to America. It is my hope that coming out of the Democratic convention here in Philadelphia, the American people will hear a much more positive, constructive, cohesive view of what we can do together in this century and how immigration can continue to be a positive and contributing part of America's future, as it has been a great part of our past.
Great. One round on campaign finance and then a few great questions from the audience. Senator Durbin, you have criticized the Citizens United decision. You've said that since the decision, we've seen the rapid rise of super PACs, and you've supported a constitutional amendment which would give Congress and the states authority to regulate and limit political spending. Why do you think Citizens United has had bad effects on American politics, and does the constitutional amendment have any chance of passing?
It's rare that I end up supporting an idea where 84% of Americans agree, but this is one of them. 84% of Americans believe that this finance system is completely broken, overwhelmed with money. And the analysis that was done late last year that showed 158 families had contributed half of the money to the presidential campaign as the end of last year. 158 families out of a nation of 350 million people. Clearly, it's moving us toward a plutocracy. And there are certain players, big players, who are having outsized impact. The Koch brothers come to mind immediately. And they say, oh, we're just going to spend $1 billion this cycle. Just $1 billion on these elections. And many of us have seen it. Now, there are those on the Democratic side, don't get me wrong. They don't quite rival what the Koch brothers have put in, but they are big spenders. I may be naive, and I hope I'm not, but I think public financing should be given a try, and I think we can still do it. I think even within the confines of the Supreme Court. I put in fair elections now. It's been changed as the Supreme Court decisions came down. Initially, it was a senator from this state was the only one who would co-sponsor it from the other side, Arlen Specter. He was one of my original co-sponsors. I can't get a single co-sponsor on the Republican side, though we keep trying. John Sarbanes of Baltimore, Maryland, has the House bill, and the two of us kind of match up in what we're trying to do. What we're trying to do is to utilize what all of us, most of us know when we look at our cell phones each day, all the emails you're receiving. This is changing the way we finance campaigns. People like Bernie Sanders become viable because of small contributions solicited over the internet and through emails. And what we're trying to do is to give you an upper hand if that's the way you go about it. Starting with the number of contributions you get in your own home state to prove viability, and then qualifying for help, some federal assistance, and also reductions in cost of radio and TV. So I think it's a good way out of this. It's not mandatory. The wealthiest people who want to be candidates can still spend all the money they want. But if you are in the category that I call mere mortals, my category, this gives you a fighting chance. Not as much money as they have, but enough to be viable, to get your message out to people. And I think that'll be a goal that we ought to continue to fight for. Do I see a prospect for it in near term? No, I don't. And do I see a constitutional amendment getting out of the Senate? No, I don't. I think that the Republicans, this has become an article of faith for them to protect the current system.
Senator Coons, you have supported the Disclose Act of 2014, which would combat dark money and require transparency. Tell us more about that and whether that has a chance of passing.
Well, I think as long as Senator McConnell of Kentucky, who's currently the majority leader, stands just deeply opposed to any disclosure, to any transparency, to any reform in campaign finance, I'm not optimistic. I certainly don't think the Disclose Act will come through in the lame duck. It is a bill, if I remember correctly, that Senator McConnell actually had supported in the past.
Yes.
Before Citizens United. One of the things that's so distressing to me about this is Buckley versus Vallejo was fairly well-settled law. And it, in brief, performed a functional analysis of campaign contributions, of equating money and speech, and recognized that Congress could strike a balance between a legitimate concern about actual corruption or the appearance of corruption if there were a flood of money influencing elections, and could construct a statutory scheme to restrain the influence of money on politics. When that was overturned in Citizens United, it opened the floodgates to just a river of money in politics. We already have a crisis of confidence in our public institutions. We already have an electorate that is despondent about some of their economic prospects and concerned about security and concerned about education. Why allow such a public opportunity for elections to nearly become auctions seems to me beyond rationality. So I refrain from criticizing the court's decisions in most cases, but this is one that I really think it was a narrowly decided case. But it really, I think, turned the First Amendment on its head in the context of campaign contributions. And I have co-sponsored relatively few amendments. This was the first one, an amendment to overturn Citizens United. I don't think the Disclose Act has any greater opportunity for enactment in this Congress. I do think after stories are written about the impact of money on this election, it is my hope that there will be a growing bipartisan commitment to this. Senator McCain of Arizona was previously a genuine crusader for campaign finance reform. He has retreated from that somewhat. If he is reelected, it's my hope that he or other Republicans who see the real impact on our campaigns will re-engage. Frankly, if nothing else, one of the worst impacts of campaign finance on our functionality as a Congress is the amount of time members of Congress dedicate to raising money. It is a serious distraction from substantive policymaking and from the kind of work and time together that could lead to meaningful bipartisan legislation. So this is one of the foundational challenges we face, really as the result of an ill-advised Supreme Court decision.
Jeffrey, if I could make one additional point, and Chris touched it, I thank you for doing it. There are many of our colleagues who believe that constitutional amendments are the answer to almost everything. And they get carried away as far as I'm personally concerned. I really honor this Constitution. I guess this is a place to do it. And I really don't want to take a paint roller to a Rembrandt. And I do recall the day when Orrin Hatch, as chairman of the Judiciary Committee, wanted to hold two constitutional amendments to be marked up in the same day. It was on a Thursday. And you needed permission, since he did it the last minute, needed permission from the members to do it. And I objected. And one, I believe, was on balanced budget, the other on crime victims or something. And Orrin came and he held the hearing on, I believe it was crime victims, and he said, I'm sorry we couldn't bring this other budget amendment in as well. We had an objection. Well, you're supposed to keep these things quiet. I raised my hand and said, I was the one who objected. And he said, well, I wasn't going to say that. And I said, I don't mind saying it. I just don't believe we ought to amend the Constitution more than once a day. And so we haven't really passed a lot of these amendments. I have reluctantly joined in this effort because I don't know any other way on Citizens United. There's some who argue a new Supreme Court after 5 years may want to revisit this, maybe. But this is one of the few that I've joined in on.
There are superb questions, but unfortunately, Senator, you have to be upstairs in 1 minute to debate Governor Rendell for the latest installment of Political Feud. So, ladies and gentlemen, you can follow the senator, go see Political Feud, and please join me in thanking our senators for a superb constitutional conversation.
Thanks, man.